My mother once told me, "Not everyone is meant to wear robes, Isabella. Some people are meant to admire them from the gallery." She said it over Sunday dinner while cutting prime rib, like she was offering me a second helping instead of serving up the cruelest assessment of my potential I had ever heard. That sentence would follow me through law school, through years of being overlooked in courtrooms, and through every family gathering where they celebrated my sister Victoria's legal victories, while treating my career like an unfortunate hobby that had gone on too long. What my family never knew was that while they were dismissing me as the family failure, I was quietly building something they could never have imagined. The sister they called too soft for law had been appointed to the federal district court. The daughter they thought lacked ambition had been confirmed by the United States Senate. The woman they treated as invisible had been entrusted with cases that would shape constitutional law for generations. Before we jump back in, tell us where you're tuning in from, and if this story touches you, make sure you're subscribed, because tomorrow, I've saved something extra special for you. My name is Isabella Martinez Chen, and I am the eldest daughter of the Martinez family, 3 generations of attorneys who built their reputation on aggressive litigation and courtroom dominance. We were raised in the shadow of the Cook County Courthouse in Chicago, where my grandfather established Martinez and Associates in 1967, representing labor unions and working-class families against corporate interests. The law was not merely our profession. It was our family identity, our shared language, and our measure of worth. My father, Roberto Martinez, had expanded the family practice into corporate defense work, representing Fortune 500 companies in complex commercial litigation. My mother, Dr. Patricia Chen Martinez, served as a legal consultant specializing in intellectual property law after completing her doctorate in patent law from Northwestern University. My younger brother Carlos had joined the firm directly after graduating from Yale Law School, specializing in mergers and acquisitions. Victoria, my younger sister by 4 years, had carved out her niche in high-profile criminal defense, representing celebrities and politicians in cases that generated significant media attention and substantial fees. And then there was me, the family member they struggled to categorize, the attorney who had chosen a different path, the sister who had somehow missed the Martinez gene for legal aggression and courtroom theatrics. The dismissal began early in my legal career, manifesting in subtle ways that accumulated over time into a comprehensive narrative of professional inadequacy. During family gatherings, conversations about legal victories would flow around me like water around a stone. When my siblings recounted their latest courtroom triumphs, my contributions to discussions were met with polite acknowledgement rather than genuine interest. My mother would introduce Victoria as our star litigator and Carlos as our future managing partner, while describing me simply as Isabella, who also practices law. The perception of my inadequacy crystallized during my 3rd year of practice, when I made a decision that would define my family's understanding of my legal career. I had been working at Morrison, Sterling & Associates, a prestigious corporate law firm in downtown Chicago, specializing in securities litigation. The position offered substantial compensation, partnership track potential, and the type of high-stakes commercial work that my family respected and understood. However, I found myself increasingly drawn to cases involving constitutional questions and civil rights issues. The technical complexities of securities law felt hollow compared to the profound impact of cases that addressed fundamental questions of justice and individual rights. When the opportunity arose to join the Federal Public Defender's Office, I made the decision that would forever mark me as the family disappointment. The announcement of my career change occurred during a Sunday dinner at my parents' house in Lincoln Park. The dining room, lined with photographs of family members in judicial robes and legal awards, provided the perfect backdrop for what would become a defining moment in my relationship with my family. As I explained my decision to leave corporate practice for public defense work, the silence that followed felt heavier than the crystal chandelier hanging above our table. My father was the first to speak, his voice carrying the careful tone he typically reserved for explaining complex legal concepts to clients. Isabella, public defense work is admirable, but it is not a career. It is volunteer work with a paycheck. You cannot build a reputation or financial security representing criminals who cannot afford proper counsel. My mother's response was more direct. Sweetheart, you have worked too hard to throw away your potential on cases that do not matter. Securities litigation builds expertise that opens doors. Public defense work closes them. Victoria, who was then in her second year at the family firm, offered what she considered practical advice. Bella, you can always do pro bono work if you want to help people. But your primary responsibility is to yourself and your future. You cannot sacrifice your career for idealism. The conversation continued for nearly 2 hours, with each family member offering variations on the same theme. My decision represented a failure to understand the realities of legal practice and a waste of the education and opportunities they had provided. No one questioned my legal abilities or my commitment to justice. Instead, they questioned my judgment, my priorities, and my understanding of what constituted professional success. What they did not understand, and what I could not adequately explain at that dinner table, was that my work in the Federal Public Defender's Office was providing me with an education in constitutional law and federal procedure that no corporate practice could match. While my siblings were negotiating contracts and filing motions in state court, I was arguing Fourth Amendment cases before federal appellate courts. While they were billing hours on document review, I was developing expertise in federal sentencing guidelines, constitutional criminal procedure, and the intricate relationships between state and federal jurisdiction. The dismissive attitude extended beyond career discussions into every aspect of family interaction. During holidays, my professional accomplishments were acknowledged briefly before conversations shifted to Victoria's latest celebrity client or Carlos's most recent corporate acquisition. When I received recognition for my appellate work or won significant constitutional cases, the family response was polite congratulations, followed by immediate redirection to what they considered more substantial achievements by my siblings. The most painful manifestation of their dismissal occurred during family photographs. Over the years, I noticed a pattern in how our family portraits were arranged and displayed. Photographs featuring Victoria in professional settings were prominently displayed throughout my parents' home. Images of Carlos receiving awards or speaking at legal conferences occupied places of honor in the living room and my father's office. Photographs that included me were relegated to less prominent locations, and several family portraits had been cropped or arranged to emphasize my siblings while minimizing my presence. The emotional impact of this consistent dismissal was profound and cumulative. Each instance of being overlooked or minimized contributed to a growing sense of isolation within my own family. I began questioning not only their perception of my career choices, but also my own understanding of professional success and personal worth. The family that had taught me to value legal excellence now seemed to consider my version of legal practice inadequate, and my achievements insignificant. During my 5th year with the Federal Public Defender's Office, I achieved a victory that should have demonstrated the value and complexity of my work. I successfully argued a case before the 7th Circuit Court of Appeals that established important precedent regarding the application of federal sentencing guidelines in cases involving constitutional violations. The decision was cited in subsequent federal cases across multiple jurisdictions and was featured in several legal journals as a significant development in federal criminal law. When I shared this achievement with my family during a gathering celebrating Victoria's latest acquittal in a high-profile embezzlement case, the response perfectly encapsulated their attitude toward my career. My mother acknowledged the accomplishment with a brief, "That's nice, dear," before immediately returning to a detailed discussion of Victoria's courtroom strategy and media coverage. My father offered a perfunctory, "Congratulations," while continuing to review documents related to Carlos's latest corporate merger. The contrast between their response to my constitutional law victory and their enthusiastic engagement with Victoria's criminal defense work could not have been more stark. This pattern of dismissal had practical consequences beyond hurt feelings. When potential clients or professional contacts asked my family members for referrals, my name was rarely mentioned. When legal colleagues sought recommendations for constitutional law expertise or federal appellate work, my family directed them to other attorneys despite my demonstrated capabilities in these areas. You cannot build a reputation or financial security representing criminals who cannot afford proper counsel. My mother's response was more direct. Sweetheart, you have worked too hard to throw away your potential on cases that do not matter. Securities litigation builds expertise that opens doors. Public defense work closes them. Victoria, who was then in her second year at the family firm, offered what she considered practical advice. Bella, you can always do pro bono work if you want to help people. But your primary responsibility is to yourself and your future. You cannot sacrifice your career for idealism. The conversation continued for nearly 2 hours, with each family member offering variations on the same theme. My decision represented a failure to understand the realities of legal practice and a waste of the education and opportunities they had provided. No one questioned my legal abilities or my commitment to justice. Instead, they questioned my judgment, my priorities, and my understanding of what constituted professional success. What they did not understand, and what I could not adequately explain at that dinner table, was that my work in the Federal Public Defender's Office was providing me with an education in constitutional law and federal procedure that no corporate practice could match. While my siblings were negotiating contracts and filing motions in state court, I was arguing Fourth Amendment cases before federal appellate courts. While they were billing hours on document review, I was developing expertise in federal sentencing guidelines, constitutional criminal procedure, and the intricate relationships between state and federal jurisdiction. The dismissive attitude extended beyond career discussions into every aspect of family interaction. During holidays, my professional accomplishments were acknowledged briefly before conversations shifted to Victoria's latest celebrity client or Carlos's most recent corporate acquisition. When I received recognition for my appellate work or won significant constitutional cases, the family response was polite congratulations, followed by immediate redirection to what they considered more substantial achievements by my siblings. The most painful manifestation of their dismissal occurred during family photographs. Over the years, I noticed a pattern in how our family portraits were arranged and displayed. Photographs featuring Victoria in professional settings were prominently displayed throughout my parents' home. Images of Carlos receiving awards or speaking at legal conferences occupied places of honor in the living room and my father's office. Photographs that included me were relegated to less prominent locations, and several family portraits had been cropped or arranged to emphasize my siblings while minimizing my presence. The emotional impact of this consistent dismissal was profound and cumulative. Each instance of being overlooked or minimized contributed to a growing sense of isolation within my own family. I began questioning not only their perception of my career choices, but also my own understanding of professional success and personal worth. The family that had taught me to value legal excellence now seemed to consider my version of legal practice inadequate, and my achievements insignificant. During my 5th year with the Federal Public Defender's Office, I achieved a victory that should have demonstrated the value and complexity of my work. I successfully argued a case before the 7th Circuit Court of Appeals that established important precedent regarding the application of federal sentencing guidelines in cases involving constitutional violations. The decision was cited in subsequent federal cases across multiple jurisdictions and was featured in several legal journals as a significant development in federal criminal law. When I shared this achievement with my family during a gathering celebrating Victoria's latest acquittal in a high-profile embezzlement case, the response perfectly encapsulated their attitude toward my career. My mother acknowledged the accomplishment with a brief, "That's nice, dear," before immediately returning to a detailed discussion of Victoria's courtroom strategy and media coverage. My father offered a perfunctory, "Congratulations," while continuing to review documents related to Carlos's latest corporate merger. The contrast between their response to my constitutional law victory and their enthusiastic engagement with Victoria's criminal defense work could not have been more stark. This pattern of dismissal had practical consequences beyond hurt feelings. When potential clients or professional contacts asked my family members for referrals, my name was rarely mentioned. When legal colleagues sought recommendations for constitutional law expertise or federal appellate work, my family directed them to other attorneys despite my demonstrated capabilities in these areas. The dismissive attitude had become so ingrained that they genuinely did not recognize the value of my expertise or the significance of my professional development. The isolation deepened during my 7th year of practice when I received an opportunity that would fundamentally change my career trajectory. Chief Judge Margaret Thompson of the Federal District Court contacted me about a position as a staff attorney specializing in constitutional research and appellate brief review. The position would provide direct experience with federal judicial procedures and expose me to the full range of federal court operations. More importantly, it represented a stepping stone toward potential judicial appointment, though I kept that aspiration private. When I announced my decision to accept the judicial staff position, my family's response revealed the depth of their misunderstanding about federal court operations and judicial career paths. They viewed the position as another example of my tendency to choose lower-profile work over opportunities for financial advancement and professional recognition. The irony was profound. They were dismissing a career move that positioned me for judicial appointment while celebrating Victoria's success in criminal defense and Carlos's advancement in corporate law. The most devastating moment occurred during a family celebration for Victoria's promotion to senior associate at the family firm. During the dinner at Gibson's Steakhouse, the conversation naturally turned to professional achievements and future goals. When my father asked about my long-term career plans, I mentioned my interest in judicial service. The laughter that followed was not malicious, but it was real and deeply hurtful. "Isabella," Victoria said with genuine affection but complete dismissal, "judicial appointments require political connections and a track record of significant legal accomplishments. You have been doing public defense work and research positions. Judges come from major law firms or prosecutorial offices with high-profile cases and substantial victories." My mother nodded in agreement. "Sweetheart, judges are typically partners in major firms or former prosecutors with extensive trial experience. Your background in public defense and research, while admirable, does not provide the foundation for judicial consideration." Carlos offered what he considered helpful advice. "Bella, if you want to pursue judicial appointment someday, you need to build a resume that includes major cases, significant victories, and substantial legal publications. You should consider returning to corporate practice or joining the U.S. Attorney's Office to develop the credentials that judicial selection committees expect." The conversation continued with detailed advice about building judicial credentials, all based on the assumption that my current career path had failed to provide the necessary foundation for judicial consideration. No one asked about my specific accomplishments, my publications in constitutional law journals, or my growing reputation among federal judges and appellate attorneys. They simply assumed that my career choices had been misguided, and that my aspirations exceeded my qualifications. What they did not know, and what I could not reveal during that dinner conversation, was that Chief Judge Thompson had already approached me about potential judicial nomination. The conversations were preliminary and confidential, but they indicated that my expertise in constitutional law and federal procedure had been recognized by the judicial community, even if it remained invisible to my family. The pattern of dismissal had become so established that even objective evidence of my professional growth and recognition failed to change their perception. When I published articles in federal law journals, they acknowledged the achievement without understanding its significance for judicial consideration. When I received invitations to speak at constitutional law conferences, they treated these opportunities as academic exercises rather than recognition of expertise. When federal judges began consulting me on complex constitutional questions, they viewed these interactions as routine professional courtesy, rather than indicators of judicial respect for my legal analysis. Preparing and narrating this story took us a lot of time, so if you are enjoying it, subscribe to our channel, it means a lot to us. Now back to the story. The emotional toll of this consistent dismissal was substantial. I found myself questioning not only my career choices, but also my own assessment of my professional development and potential. The family that had taught me to value legal excellence now seemed to consider my version of excellence inadequate. The people who should have been my strongest supporters had become inadvertent obstacles to my confidence and professional growth. The isolation was particularly acute during professional achievements that I could not share due to confidentiality requirements. Federal judicial work often involves sensitive cases and confidential deliberations that cannot be discussed publicly. While my siblings could celebrate their victories openly and receive family recognition for their accomplishments, many of my most significant contributions to constitutional law remained confidential and therefore invisible to my family. This dynamic created a cycle where my most important work remained unknown, while my family continued to view my career through the lens of their limited understanding of federal practice and judicial operations. They measured my success against corporate law standards and criminal defense metrics that were inappropriate for evaluating constitutional law expertise and federal judicial preparation. The breaking point approached during my 9th year of federal practice, when the judicial nomination process began in earnest. The preliminary discussions with judicial selection committees required absolute confidentiality, preventing me from sharing this development with my family. As the process advanced through various stages of review and evaluation, I found myself maintaining normal family relationships while concealing the most significant professional opportunity of my career. The irony became increasingly painful as my family continued offering advice about building judicial credentials while remaining unaware that I was already being considered for federal appointment. Their well-intentioned suggestions about career development and professional positioning revealed the enormous gap between their perception of my accomplishments and the reality of my professional standing within the federal legal community. During this period, I made a decision that would prove crucial for the eventual revelation of my true professional status. Rather than attempting to correct my family's misperceptions or provide hints about my judicial nomination, I chose to let their assumptions stand while quietly continuing the confirmation process. This decision was motivated partly by confidentiality requirements, and partly by a desire to allow my eventual appointment to speak for itself about the value of my career choices and professional development. The months leading up to my Senate confirmation hearing were characterized by this strange duality of maintaining family relationships based on their dismissive assumptions while privately preparing for one of the most significant professional appointments in American law. The contrast between their perception and reality had become so extreme that the eventual revelation would fundamentally challenge everything they believed about legal careers, professional success, and my place within the family hierarchy. The final preparation for this revelation occurred during a family gathering celebrating Victoria's latest courtroom victory. As my relatives discussed the qualities required for judicial appointment and the career paths that led to federal service, I realized that my appointment would represent more than personal professional achievement. It would demonstrate that excellence comes in many forms, that traditional career paths are not the only routes to significant accomplishment, and that dismissive assumptions about professional potential can be profoundly wrong. The transformation from family disappointment to federal judge was nearly complete, but the revelation remained ahead, waiting for the moment when my sister's legal consultation would require her to address me not as the family failure but as, Your Honor. The Federal Public Defender's Office occupied 3 floors of a converted warehouse in downtown Chicago, its utilitarian architecture reflecting the practical nature of constitutional defense work. Unlike the marble lobbies and mahogany conference rooms of prestigious law firms, our offices featured fluorescent lighting, metal desks, and wall-mounted bookshelves overflowing with federal statutes and appellate decisions. The environment might have appeared modest to outside observers, but within these unremarkable walls, I was receiving an education in federal constitutional law that few attorneys would ever experience. My supervisor, Elena Rodriguez, had served as a federal public defender for 15 years, after completing a judicial clerkship with the Ninth Circuit Court of Appeals. She understood that effective constitutional defense required mastery of complex legal doctrine across multiple areas of federal law. During my first week, she explained the intellectual demands of our work, with characteristic directness. Isabella, corporate lawyers master contract interpretation and securities regulations. We master the Constitution. Every case requires analysis of Fourth Amendment search and seizure law, Fifth Amendment self-incrimination protections, Sixth Amendment right to counsel provisions, Eighth Amendment cruel and unusual punishment prohibitions, and 14th Amendment due process guarantees. You will learn more constitutional law in 2 years here than most attorneys encounter in their entire careers. Her assessment proved accurate. Within months, I was researching constitutional questions that required deep understanding of Supreme Court precedent, federal appellate decisions, and the evolving interpretation of constitutional provisions across different jurisdictions. The intellectual rigor demanded by federal constitutional defense exceeded anything I had encountered in corporate practice, where legal analysis typically focused on contractual language and regulatory compliance, rather than fundamental questions of governmental power and individual rights. The education began with Fourth Amendment jurisprudence, the constitutional provision governing search and seizure law. Federal criminal cases frequently involved questions about the validity of police searches, the scope of warrant requirements, and the application of various exceptions to constitutional protections. Understanding these issues required mastery of decades of Supreme Court decisions that had interpreted Fourth Amendment language in increasingly complex factual situations. My first major constitutional research project involved analyzing the application of the automobile exception to Fourth Amendment warrant requirements in cases involving digital evidence. The legal question required tracing the development of automobile exception doctrine from its origins in Prohibition-era cases through its modern application to electronic devices found in vehicles. The research demanded understanding not only the constitutional principles involved, but also the technological developments that had created new categories of evidence requiring constitutional analysis. The complexity of this research revealed the sophisticated legal reasoning required for effective federal constitutional defense. Unlike corporate legal research, which typically involved interpreting specific contractual provisions or regulatory requirements, constitutional research required understanding the historical development of legal doctrine, the policy considerations underlying judicial decisions, and the potential implications of different interpretational approaches for future cases. Fifth Amendment jurisprudence provided another area of intensive education. The constitutional protection against self-incrimination intersected with federal criminal procedure in numerous complex ways, from the application of Miranda warnings in federal investigations to the scope of immunity grants in federal prosecution. Understanding these issues required mastery of Supreme Court doctrine regarding the privilege against self-incrimination, the requirements for valid Miranda waivers, and the various forms of immunity available under federal law. My work on Fifth Amendment issues included analyzing the constitutional implications of federal agents' interrogation techniques in white-collar criminal investigations. The legal research required understanding the evolution of self-incrimination doctrine from its historical origins in English common law through its modern application to sophisticated federal investigative techniques. The intellectual demands of this analysis exceeded anything I had encountered in corporate practice, requiring deep understanding of constitutional history, criminal procedure, and the practical implications of different legal interpretations. Sixth Amendment right to counsel issues provided particularly complex educational opportunities. Federal criminal cases often involved questions about the effectiveness of legal representation, the timing of counsel attachment, and the scope of attorney-client privilege in federal investigations. Understanding these issues required mastery of Supreme Court decisions regarding the right to counsel, federal appellate court interpretations of effectiveness standards, and the practical implications of different constitutional interpretations for criminal defense practice. The most intellectually demanding Sixth Amendment work involved analyzing the constitutional requirements for effective assistance of counsel in capital cases. This research required understanding Supreme Court decisions regarding death penalty representation, federal appellate standards for evaluating attorney effectiveness, and the complex intersection between constitutional requirements and practical limitations of criminal defense practice. The depth of legal analysis required for this work demonstrated the sophisticated constitutional expertise that federal public defense practice demanded. Eighth Amendment cruel and unusual punishment jurisprudence provided another area of intensive constitutional education. Federal criminal cases frequently involved sentencing issues that required analysis of proportionality requirements, the constitutional limitations on particular forms of punishment, and the evolving standards of decency that governed Eighth Amendment interpretation. Understanding these issues required mastery of Supreme Court decisions regarding punishment limitations, federal appellate court applications of proportionality analysis, and the complex relationship between constitutional requirements and federal sentencing guidelines. My work on Eighth Amendment issues included analyzing the constitutional implications of lengthy federal sentences for nonviolent offenses. The legal research required understanding the development of proportionality analysis from its origins in English law through its modern application to federal sentencing practices. The intellectual complexity of this analysis required deep understanding of constitutional history, sentencing policy, and the practical implications of different constitutional interpretations for federal criminal practice. 14th Amendment due process analysis provided the most comprehensive constitutional education. Federal criminal cases involved both substantive and procedural due process questions that required understanding fundamental fairness requirements, the scope of liberty interests protected by the Constitution, and the procedural safeguards required for valid governmental action. The breadth of due process doctrine encompassed virtually every aspect of federal criminal procedure, From the validity of investigative techniques to the fairness of sentencing proceedings, the intellectual demands of due process analysis required understanding Supreme Court decisions spanning more than a century of constitutional interpretation. Due process doctrine had evolved through numerous historical periods, each characterized by different approaches to the relationship between governmental power and individual rights. Mastering this evolution required deep understanding of constitutional history, political theory, and the practical implications of different legal philosophies for contemporary federal practice. Beyond constitutional law, federal public defense practice provided intensive education in federal criminal procedure, evidence law, and appellate advocacy. Federal criminal cases were governed by the Federal Rules of Criminal Procedure, which differed significantly from state criminal procedure in numerous important respects. Understanding federal criminal procedure required mastery of complex rules governing everything from grand jury proceedings to post-conviction appeals. Federal evidence law provided another area of specialized education. The Federal Rules of Evidence governed the admissibility of evidence in federal criminal cases, and these rules often differed from state evidence law in subtle but important ways. Understanding federal evidence law required mastery of complex rules regarding hearsay exceptions, expert testimony, and the admission of character evidence. The practical application of federal evidence rules in criminal cases required understanding not only the technical requirements of each rule, but also the strategic implications of different evidentiary approaches for effective defense advocacy. Appellate advocacy skills developed through extensive practice in federal appellate courts. Federal public defenders regularly argued cases before the Seventh Circuit Court of Appeals, and these arguments required mastery of appellate procedure, brief writing, and oral advocacy techniques. The intellectual demands of federal appellate advocacy exceeded those of trial court practice, requiring deep understanding of legal doctrine, policy considerations, and the institutional role of appellate courts in developing federal law. My first appellate argument occurred during my third year with the Federal Public Defender's Office. The case involved Fourth Amendment questions regarding the scope of search incident to arrest in cases involving digital devices. Preparing for oral argument required mastering not only the specific legal issues involved, but also the broader policy considerations that influence judicial decision-making in constitutional cases. The oral argument experience provided education in judicial reasoning and constitutional interpretation that could not be obtained through other forms of legal practice. Federal appellate judges asked probing questions about constitutional doctrine, policy implications, and the practical consequences of different legal interpretations. Responding effectively to these questions required deep understanding of constitutional law, federal criminal procedure, and the institutional considerations that influenced judicial decision-making. The education continued through extensive legal writing responsibilities. Federal public defenders regularly prepared appellate briefs, motions to suppress evidence, and sentencing memoranda that required sophisticated legal analysis and persuasive writing. The quality standards for federal court submissions demanded precision in legal research, clarity in legal reasoning, and effectiveness in legal advocacy that exceeded the requirements of most other forms of legal practice. My brief writing experience included preparing a petition for certiorari to the Supreme Court in a case involving Fifth Amendment questions regarding the scope of immunity grants in federal prosecution. The petition required mastering Supreme Court procedure, analyzing constitutional doctrine across multiple jurisdictions, and presenting legal arguments in the highly specialized format required for Supreme Court consideration. The intellectual demands of Supreme Court practice represented the highest level of legal analysis and advocacy skills. The practical education extended beyond legal research and writing to include client counseling, negotiation, and trial advocacy in federal court. Federal criminal defendants faced unique challenges that required specialized knowledge of federal sentencing guidelines, federal prison systems, and federal prosecution practices. Effective client representation required understanding not only the legal issues involved, but also the practical implications of different strategic approaches for client outcomes. Federal sentencing guidelines provided particularly complex educational opportunities. The guidelines system created a detailed framework for determining appropriate sentences in federal criminal cases, and this framework required understanding numerous factors, including offense characteristics, criminal history, and various adjustments that could affect final sentencing calculations. Mastering federal sentencing law required understanding not only the technical requirements of the guidelines, but also the policy considerations underlying sentencing decisions and the practical implications of different sentencing approaches for client outcomes. Trial advocacy in federal court provided education in evidence presentation, witness examination, and jury persuasion in the specialized context of federal criminal practice. Federal criminal trials involved unique procedural requirements and evidentiary considerations that differed from state criminal practice. Understanding federal trial practice required mastery of complex rules governing everything from jury selection to post-trial motions. The most valuable aspect of this education was its integration across multiple areas of federal law. Unlike corporate practice, where attorneys often specialized in narrow areas of expertise, federal constitutional defense required understanding the interconnections between constitutional law, criminal procedure, evidence law, and sentencing practice. This integrated understanding provided comprehensive knowledge of federal legal systems that few attorneys possessed. Professional development opportunities enhanced the formal education through conferences, continuing legal education programs, and collaboration with leading constitutional law experts. The federal public defense community included some of the nation's most knowledgeable constitutional lawyers, and working within this community provided access to expertise and insight that could not be obtained through other career paths. My participation in national conferences on constitutional law provided exposure to cutting-edge legal scholarship and developing trends in constitutional interpretation. These conferences brought together federal judges, law professors, and practicing attorneys to discuss complex constitutional questions and their implications for federal practice. The intellectual stimulation of these professional gatherings enhanced my understanding of constitutional law and provided insight into the judicial reasoning that shaped constitutional doctrine. Continuing legal education programs specifically designed for federal practitioners provided specialized training in emerging areas of federal law. These programs covered topics ranging from new Supreme Court decisions to developing trends in federal enforcement priorities. The specialized nature of federal practice required continuous learning to maintain effectiveness in representing clients facing federal charges. Collaboration with law professors and constitutional law scholars provided opportunities to engage with academic perspectives on constitutional interpretation and federal practice. These collaborations often involved joint research projects, co-authored articles, or consultation on complex constitutional questions. The academic perspective enhanced my understanding of constitutional theory and provided insight into the scholarly debates that influenced judicial reasoning. The education culminated in recognition from the federal judicial community for expertise in constitutional law and federal practice. Federal judges began consulting me on complex constitutional questions, inviting me to participate in judicial education programs, and recommending my work to other attorneys handling similar constitutional issues. This recognition validated the depth and sophistication of the education I had received through federal public defense practice. By my 7th year with the Federal Public Defender's Office, I had developed expertise in constitutional law that exceeded that of most attorneys practicing in federal court. The comprehensive nature of this education, combined with extensive practical experience in federal appellate advocacy, positioned me as one of the leading constitutional practitioners in the federal judicial district. This expertise would prove crucial for the judicial appointment process that lay ahead, though my family remained unaware of both my professional development and my growing reputation within the federal legal community. The hidden education had prepared me not merely for effective constitutional advocacy, but for the judicial reasoning and constitutional analysis that would be required for federal judicial service. The foundation had been established for the next phase of professional development that would ultimately lead to federal judicial appointment and the revelation that would transform my family's understanding of legal careers and professional success. The federal courthouse at 219 South Dearborn Street became my second home during the years when my family believed I was struggling in an unremarkable legal career. The imposing structure, with its 27 floors of marble corridors and mahogany-paneled courtrooms, housed the United States District Court for the Northern District of Illinois. Within these walls, I occupied a unique position that provided unprecedented access to the inner workings of federal judicial administration, constitutional interpretation, and the decision-making processes that shaped American jurisprudence. My transition from the Federal Public Defender's Office to the position of staff attorney for Chief Judge Margaret Thompson occurred during my 8th year of federal practice. The appointment came after Judge Thompson observed my appellate work in several high-profile constitutional cases where my briefs had influenced significant federal court decisions. She approached me with an opportunity that would provide direct exposure to federal judicial operations, while allowing me to contribute to the development of constitutional law from within the judicial system itself. The role of judicial staff attorney remained largely invisible to those outside the federal court system. Unlike law clerks, who worked directly with individual judges on specific cases, staff attorneys served the entire court by conducting research on complex legal questions, preparing memoranda on emerging constitutional issues, and analyzing the broader implications of federal court decisions. This position provided comprehensive exposure to every aspect of federal judicial operations, from routine case management to the most sophisticated questions of constitutional interpretation. The invisible advantage began with access to judicial reasoning processes that remained hidden from external observers. Staff attorneys participated in confidential discussions about legal interpretation, observed judicial deliberations on complex constitutional questions, and contributed to the analytical frameworks that guided federal court decision-making. This exposure provided insight into the intellectual rigor and careful consideration that characterized federal judicial reasoning, knowledge that would prove invaluable for eventual judicial service. Federal judges approached constitutional interpretation with systematic methodology that reflected both legal expertise and practical wisdom. Their analysis began with comprehensive examination of relevant constitutional text, proceeded through careful consideration of historical interpretation and Supreme Court precedent, and concluded with thoughtful evaluation of the practical implications of different interpretational approaches. Observing this methodology provided education in judicial reasoning that could not be obtained through any other professional experience. The advantage extended to understanding federal court administration and case management procedures that affected every aspect of federal legal practice. Staff attorneys worked closely with the clerk of court, case management personnel, and judicial administration officials to ensure efficient operation of federal court systems. This exposure provided comprehensive knowledge of federal court procedures, filing requirements, and administrative practices that enhanced effectiveness in federal court practice. Federal case management involved sophisticated systems for tracking complex litigation, coordinating multi-district proceedings, and ensuring compliance with federal procedural requirements. Understanding these systems required mastery of federal court technology, case management software, and the administrative procedures that supported effective judicial operations. This knowledge provided practical advantages for federal court practice that most attorneys never acquired. The invisible advantage included exposure to federal sentencing practices and the practical application of federal sentencing guidelines. Staff attorneys regularly analyzed sentencing memoranda, reviewed departure motions, and researched complex questions regarding the application of sentencing enhancements and reductions. This work provided comprehensive understanding of federal sentencing law that exceeded the knowledge possessed by most federal practitioners. Federal sentencing involved numerous considerations beyond the basic calculation of guideline ranges. Judges evaluated factors including acceptance of responsibility, cooperation with federal authorities, criminal history variations, and the unique circumstances of individual defendants. Understanding these considerations required knowledge of federal sentencing policy, the practical operation of federal correctional systems, and the broader implications of sentencing decisions for both defendants and society. Constitutional law development represented the most intellectually stimulating aspect of the staff attorney position. Federal district courts regularly confronted novel constitutional questions that required careful analysis of Supreme Court precedent, consideration of developing trends in constitutional interpretation, and evaluation of the potential implications of different constitutional approaches. Contributing to this analysis provided education in constitutional reasoning that prepared me for the constitutional analysis required for judicial service. The invisible advantage extended to understanding federal criminal law enforcement priorities, and the practical operation of federal investigative agencies. Staff attorneys regularly reviewed cases involving FBI investigations, DEA operations, ATF enforcement actions, and other federal law enforcement activities. This exposure provided comprehensive knowledge of federal criminal law enforcement that enhanced understanding of the practical context within which constitutional protections operated. Federal investigations involved sophisticated techniques including electronic surveillance, undercover operations, financial analysis, and international cooperation. Understanding these techniques required knowledge of federal investigative authorities, constitutional limitations on federal law enforcement, and the practical challenges faced by federal investigators in developing cases against sophisticated criminal organizations. Immigration law provided another area where the staff attorney position offered unique educational advantages. Federal courts regularly addressed complex immigration questions involving constitutional protections for non-citizens, the scope of federal immigration authority, and the intersection between immigration law and federal criminal law. This work required understanding immigration statutes, federal court jurisdiction over immigration matters, and the constitutional principles that governed federal immigration enforcement. Federal immigration cases often involved individuals facing both criminal prosecution and immigration consequences, creating complex legal situations that required coordination between federal criminal courts and immigration authorities. Understanding these intersections required knowledge of immigration law, federal criminal procedure, and the practical implications of different legal outcomes for affected individuals. Civil rights litigation provided exposure to federal constitutional law in its most direct application to individual circumstances. Federal courts regularly addressed civil rights claims involving allegations of constitutional violations by federal, state, and local officials. Staff attorneys analyzed these cases to identify emerging trends in civil rights law, evaluate the effectiveness of different legal remedies, and assess the broader implications of civil rights decisions for constitutional development. Constitutional tort litigation required understanding Section 1983 claims, Bivens actions, and other federal civil rights statutes that provided remedies for constitutional violations. This work involved analysis of qualified immunity doctrine, municipal liability standards, and the practical challenges involved in providing effective remedies for constitutional violations. Federal appellate practice provided the most direct preparation for judicial reasoning and constitutional analysis. Staff attorneys regularly prepared memoranda analyzing potential appeals, evaluating the likelihood of appellate review, and assessing the broader implications of district court decisions for federal law development. This work required understanding appellate court priorities, the standards governing appellate review, and the strategic considerations that influenced appellate decision-making. The Seventh Circuit Court of Appeals maintained particularly high standards for legal analysis and constitutional reasoning. Understanding these standards required knowledge of appellate court preferences, the analytical frameworks favored by different judges, and the practical considerations that influenced appellate court decision-making. This knowledge provided significant advantages for effective appellate advocacy and judicial reasoning. Federal judicial education programs provided additional opportunities for professional development and exposure to cutting-edge legal scholarship. Staff attorneys regularly participated in judicial conferences, constitutional law seminars, and federal practice institutes that brought together federal judges, law professors, and leading practitioners to discuss complex legal questions and emerging trends in federal law. The Federal Judicial Center sponsored numerous educational programs designed to enhance judicial reasoning and constitutional analysis. These programs covered topics ranging from new Supreme Court decisions to developing trends in federal enforcement priorities. Participation in these programs provided exposure to judicial reasoning processes and constitutional interpretation that enhanced preparation for judicial service. Professional recognition within the federal judicial community began during my third year as staff attorney, when federal judges from other districts began requesting my research and analysis on complex constitutional questions. This recognition reflected the quality and sophistication of my constitutional law expertise and my growing reputation as a reliable source of careful legal analysis. Federal judges valued staff attorney contributions because these attorneys provided objective legal analysis without the advocacy perspective that characterized practicing attorney submissions. This objectivity, combined with comprehensive knowledge of federal law and constitutional doctrine, made staff attorney research particularly valuable for judicial decision-making. The invisible advantage culminated in direct involvement with judicial selection processes and the practical operation of federal judicial appointment procedures. Staff attorneys worked closely with chief judges and judicial administration officials to evaluate potential judicial nominees, assess the qualifications required for federal judicial service, and understand the practical considerations that influenced judicial appointment decisions. Federal judicial selection involved comprehensive evaluation of potential nominees, including their legal expertise, judicial temperament, professional experience, and demonstrated commitment to constitutional principles. Understanding these evaluation criteria provided insight into the qualifications required for federal judicial service and the practical considerations that influenced appointment decisions. Constitutional scholarship provided additional professional development opportunities through collaboration with law professors and participation in academic conferences on constitutional law. These collaborations enhanced understanding of constitutional theory and provided exposure to the scholarly debates that influenced judicial reasoning and constitutional interpretation. The American Constitution Society and the Federalist Society sponsored numerous conferences and symposia that brought together federal judges, constitutional scholars, and practicing attorneys to discuss complex constitutional questions. Participation in these programs provided exposure to different perspectives on constitutional interpretation and the theoretical frameworks that guided judicial reasoning. Legal writing opportunities enhanced professional recognition and demonstrated expertise in constitutional law and federal practice. Staff attorneys regularly contributed to judicial opinions, prepared memoranda that influenced federal court decisions, and authored articles for legal publications that addressed complex questions of constitutional interpretation and federal practice. Federal court opinions required careful legal reasoning, comprehensive analysis of relevant precedent, and clear articulation of the legal principles governing federal court decisions. Contributing to this writing provided experience in judicial reasoning and constitutional analysis that prepared me for the intellectual demands of federal judicial service. The invisible advantage provided by the staff attorney position created comprehensive preparation for federal judicial appointment that exceeded the qualifications possessed by most potential nominees. The combination of constitutional law expertise, federal court experience, judicial reasoning skills, and professional recognition within the federal judicial community established a foundation for judicial service that would eventually lead to federal judicial nomination. My family remained unaware of these professional developments and continued to view my career through the limited perspective of their understanding of legal practice. They could not recognize the significance of staff attorney service or understand the sophisticated legal expertise required for effective performance in this role. Their dismissive attitude persisted despite objective evidence of professional growth and recognition within the federal judicial community. The contrast between family perception and professional reality continued to widen as my expertise and recognition within the federal legal community grew. The invisible advantage had prepared me not merely for effective federal court practice, but for the constitutional analysis and judicial reasoning that would be required for federal judicial service. The foundation had been established for the judicial appointment process that would ultimately transform family dismissal into recognition of judicial authority. The constitutional law expertise I had developed over 9 years of federal practice represented a level of specialized knowledge that few attorneys possessed, yet it remained entirely invisible to my family and their understanding of legal accomplishment. While they measured professional success through high-profile client victories and substantial legal fees, I had been quietly building comprehensive mastery of federal constitutional interpretation, appellate advocacy, and judicial reasoning that would prove essential for federal judicial service. The depth of my constitutional expertise became evident through a series of complex cases that required sophisticated analysis of Supreme Court precedent and innovative application of constitutional principles to emerging legal questions. Unlike the straightforward contractual disputes and regulatory compliance matters that characterized my siblings' corporate practice, constitutional law demanded understanding of fundamental governmental principles, historical legal development, and the practical implications of constitutional interpretation for American society. My first major constitutional victory occurred during my 6th year of federal practice, when I successfully argued before the Seventh Circuit Court of Appeals that federal sentencing guidelines violated the Eighth Amendment's prohibition against cruel and unusual punishment in cases involving nonviolent financial crimes. The case required comprehensive analysis of proportionality doctrine, examination of historical punishment practices, and sophisticated argumentation regarding the constitutional limitations on federal sentencing authority. The legal research for this appeal required mastering centuries of constitutional development, from English common law origins through contemporary Supreme Court interpretation of punishment limitations. The brief ultimately submitted to the Seventh Circuit comprised 237 pages of legal analysis, supported by extensive examination of historical sources, comparative legal systems, and empirical research regarding punishment effectiveness. The intellectual rigor required for this constitutional analysis exceeded anything demanded by traditional corporate legal practice. The appellate oral argument presented before 3 federal appellate judges demonstrated the sophisticated advocacy skills required for effective constitutional practice. The judges posed complex questions about constitutional theory, historical interpretation, and the practical implications of different constitutional approaches for federal criminal justice. Responding effectively to these inquiries required deep understanding of constitutional doctrine, quick analytical thinking, and the ability to articulate complex legal principles clearly and persuasively. The Seventh Circuit's decision adopting my constitutional analysis established important precedent regarding federal sentencing limitations and was subsequently cited by federal courts across multiple jurisdictions. The opinion specifically noted the quality of the constitutional research and the innovative application of Eighth Amendment doctrine to contemporary sentencing practices. This recognition from federal appellate judges validated the sophistication of my constitutional expertise and established my reputation within the federal judicial community. Constitutional scholarship represented another dimension of expertise that remained invisible to my family, despite its significance within the legal academic community. Federal constitutional practice required continuous engagement with developing legal scholarship, empirical research regarding constitutional implementation, and theoretical frameworks that guided constitutional interpretation. This scholarly engagement enhanced practical constitutional advocacy while contributing to broader understanding of constitutional principles. My first major constitutional law article, published in the Northwestern University Law Review, analyzed the intersection between Fourth Amendment privacy protections and emerging digital surveillance technologies. The article required comprehensive examination of Supreme Court precedent regarding privacy expectations, analysis of technological developments that challenge traditional constitutional frameworks, and innovative proposals for adapting constitutional doctrine to contemporary surveillance capabilities. The research for this article involved collaboration with computer science experts, examination of foreign constitutional approaches to digital privacy, and extensive analysis of federal court decisions addressing electronic surveillance questions. The interdisciplinary nature of this research required understanding not only constitutional law, but also technology policy, privacy theory, and the practical operations of federal law enforcement agencies. The Law Review article received recognition from constitutional scholars across the country and was cited by federal courts addressing similar constitutional questions. The Federal Bureau of Investigation requested copies for their legal training programs, and several federal judges referenced the analysis in opinions addressing digital privacy issues. This professional recognition demonstrated the practical value of my constitutional scholarship while establishing my expertise in emerging areas of constitutional law. Federal appellate advocacy skills developed through extensive practice before the Seventh Circuit Court of Appeals represented another area of specialized expertise that exceeded the qualifications possessed by most attorneys practicing federal law. Effective appellate advocacy required mastery of complex procedural requirements, sophisticated legal writing capabilities, and the oral advocacy skills necessary for persuasive presentation before federal appellate judges. The preparation required for federal appellate arguments involved comprehensive analysis of legal precedent, strategic evaluation of different argumentative approaches, and careful consideration of the policy implications that influenced appellate decision-making. Unlike trial court practice, which focused primarily on factual development and evidence presentation, Appellate advocacy required pure legal analysis and the ability to articulate complex constitutional principles in accessible terms. My appellate advocacy record included successful arguments in 17 federal appeals, with favorable outcomes in 14 cases involving complex constitutional questions. These victories included establishing new precedent regarding Fifth Amendment self-incrimination protections, expanding Fourth Amendment privacy rights in digital contexts, and clarifying Sixth Amendment right to counsel requirements in federal capital cases. The consistency of these appellate victories demonstrated sophisticated legal analysis and effective advocacy skills. Federal judicial education programs provided additional opportunities to demonstrate constitutional expertise while contributing to judicial understanding of complex legal questions. Federal judges regularly requested my participation in educational seminars addressing constitutional interpretation, federal criminal procedure, and emerging trends in federal law. These programs provided direct interaction with federal judges and opportunities to influence judicial thinking regarding constitutional questions. The Federal Judicial Center invited me to present analysis of constitutional developments at their annual conference for federal district judges. The presentation addressed recent Supreme Court decisions regarding digital privacy and their implications for federal criminal practice. The analysis required comprehensive understanding of constitutional doctrine, practical knowledge of federal investigative techniques, and the ability to communicate complex legal concepts to judicial audiences. Federal judges' positive response to this presentation led to additional invitations for judicial education programs and requests for written analysis of complex constitutional questions. Chief Judge Thompson specifically commended the clarity and sophistication of my constitutional analysis, noting that my presentations enhanced judicial understanding of emerging constitutional issues and provided valuable guidance for federal court decision-making. Constitutional consultation work for federal agencies demonstrated another dimension of expertise that remained invisible to my family despite its significance for federal policy development. Federal agencies regularly confronted constitutional questions regarding the scope of their regulatory authority, the procedural requirements governing administrative action, and the constitutional limitations on federal enforcement activities. The Department of Justice requested my analysis of constitutional questions regarding federal immigration enforcement authority and the procedural protections required for immigration proceedings. This consultation required understanding both constitutional law and federal immigration statutes, analysis of the complex relationship between federal and state authority in immigration matters, and evaluation of the constitutional protections applicable to non-citizens facing federal enforcement action. The constitutional analysis provided to federal agencies required the highest level of legal expertise, because agency actions based on this analysis would affect thousands of individuals and could face constitutional challenge in federal court. The responsibility for providing accurate constitutional guidance to federal agencies demonstrated recognition of my expertise by federal legal officials and established my reputation as a reliable source of sophisticated constitutional analysis. Professional recognition within the constitutional law community extended beyond federal practice to include collaboration with leading constitutional scholars and participation in academic conferences addressing cutting-edge constitutional questions. These professional relationships enhanced my understanding of constitutional theory, while providing opportunities to contribute to scholarly debates regarding constitutional interpretation and implementation. The American Constitution Society invited me to participate in their annual symposium on constitutional criminal procedure, where I presented analysis of recent Supreme Court decisions and their implications for federal criminal practice. The presentation required comprehensive understanding of constitutional doctrine, awareness of developing trends in constitutional interpretation, and the ability to articulate complex legal analysis for diverse professional audiences. Constitutional scholars from leading law schools requested collaboration on research projects addressing complex questions of constitutional interpretation and federal practice. These collaborations enhanced my understanding of constitutional theory while contributing to academic scholarship that influenced judicial reasoning and constitutional development. Federal court clerkship supervision provided additional opportunities to demonstrate constitutional expertise while contributing to judicial education and legal profession development. Chief Judge Thompson appointed me to supervise federal court clerks working on complex constitutional questions, recognizing my expertise in constitutional analysis and my ability to guide developing legal professionals. The supervision of federal court clerks required comprehensive understanding of constitutional doctrine, practical knowledge of federal court operations, and effective teaching capabilities. Federal court clerks worked directly with federal judges on constitutional interpretation and judicial opinion writing, requiring supervisors to possess the highest level of constitutional expertise and judicial reasoning skills. Federal court clerks supervised under my guidance consistently receive commendation from federal judges for the quality of their constitutional analysis and legal writing. Several former clerks specifically credited my guidance with enhancing their understanding of constitutional law and preparing them for successful legal careers. This recognition validated my expertise while demonstrating effective teaching and mentorship capabilities. Constitutional litigation in federal court required sophisticated understanding of federal procedural requirements, strategic evaluation of constitutional claims, and effective advocacy before federal judges with extensive constitutional expertise. Federal constitutional litigation differed significantly from state court practice in terms of procedural complexity, substantive legal standards, and the sophistication of legal analysis required for effective advocacy. My constitutional litigation record included successful representation of clients in complex federal cases involving First Amendment free speech protections, Fourth Amendment privacy rights, Fifth Amendment due process guarantees, and Eighth Amendment punishment limitations. These cases required innovative legal arguments, comprehensive factual development, and sophisticated constitutional analysis that demonstrated mastery of federal constitutional law. The most significant constitutional litigation victory involved representing a client challenging federal surveillance programs under Fourth Amendment privacy protections. The case required comprehensive analysis of Supreme Court precedent regarding electronic surveillance, examination of federal statutory authority for surveillance programs, and innovative constitutional arguments regarding privacy expectations in digital communications. The federal district court's decision adopting my constitutional analysis established important precedent regarding federal surveillance limitations and was subsequently cited by federal courts across the country. The opinion specifically noted the sophistication of the constitutional research and the innovative application of Fourth Amendment doctrine to contemporary surveillance technology. Constitutional training programs for legal professionals demonstrated another dimension of expertise that enhanced recognition within the legal community while contributing to professional development across the federal legal system. Federal agencies, legal organizations, and law schools regularly requested training programs addressing complex constitutional questions and their practical application in federal practice. The Chicago Bar Association invited me to develop and present a comprehensive training program on constitutional criminal procedure for attorneys practicing in federal court. The program required distilling complex constitutional doctrine into accessible presentations while providing practical guidance for effective federal court practice. Federal prosecutors attended these training programs to enhance their understanding of constitutional limitations on federal enforcement authority and the practical requirements for constitutional compliance in federal criminal investigations. The positive response from federal prosecutors validated the practical value of my constitutional expertise while establishing my reputation as an effective educator. The accumulated constitutional expertise represented a level of specialized knowledge that few attorneys possessed, and that qualified me for the most demanding positions within the federal legal system. The combination of constitutional scholarship, appellate advocacy skills, federal court experience, and professional recognition within the judicial community established comprehensive qualifications for federal judicial service that exceeded those possessed by most potential judicial nominees. My family remained entirely unaware of this professional development and continued to view my career through the limited lens of their understanding of legal practice. They could not recognize the significance of constitutional expertise or understand the sophisticated qualifications required for federal judicial service. Their dismissive attitude persisted despite objective evidence of professional accomplishment and recognition within the federal legal community. The expertise nobody recognized had prepared me for the constitutional analysis and judicial reasoning that would be required for federal judicial service, while establishing the professional reputation that would support eventual judicial nomination. The foundation had been established for the transformation that would challenge every assumption my family had made about legal careers and professional success. The crystallizing moment arrived on a Tuesday evening in October, Precisely at 6:47 p.m., as I sat in my modest office on the 20th floor of the federal courthouse, reviewing a complex constitutional analysis for Chief Judge Thompson. The autumn light filtered through the tall windows, casting long shadows across the stacks of Supreme Court decisions and federal appellate opinions that had become the foundation of my professional existence. In that singular moment, 9 years of accumulated constitutional expertise, federal court experience, and judicial recognition organized themselves into perfect clarity regarding both the depth of my qualifications and the trajectory that lay ahead. The immediate catalyst was a memorandum from the Administrative Office of the United States Courts regarding anticipated judicial vacancies in the Northern District of Illinois. The document, marked confidential and distributed only to senior judicial staff, outlined the retirement plans of 3 federal district judges over the following 18 months. Chief Judge Thompson had requested my analysis of the constitutional caseload implications and the specialized expertise that would be required for effective judicial service in these positions. As I reviewed the projected caseload data, examining the complex constitutional questions that would require judicial resolution, I experienced a profound moment of recognition. The cases described in the administrative memorandum involved precisely the areas of constitutional law where I had developed comprehensive expertise over the previous 9 years. The Fourth Amendment digital privacy questions, Fifth Amendment self-incrimination complexities, Sixth Amendment right to counsel issues, and Eighth Amendment proportionality analyses represented the core of my professional specialization. The realization struck with startling clarity that my unconventional career path had prepared me not merely for effective constitutional advocacy, but for the constitutional interpretation and judicial reasoning that federal judicial service demanded. The expertise I had developed through federal public defense work, constitutional scholarship, appellate advocacy, and judicial staff service encompassed precisely the qualifications that federal judicial selection committees sought in potential nominees. The constitutional law mastery that my family dismissed as impractical specialization represented exactly the sophisticated legal knowledge required for federal judicial appointment. The federal court experience they failed to recognize as significant provided the practical understanding of judicial operations that appointment committees considered essential. The scholarly recognition they overlooked demonstrated the intellectual credibility that validated potential judicial nominees. The crystallizing moment extended beyond professional recognition to encompass a fundamental transformation in my understanding of career development, professional success, and the relationship between personal choices and ultimate achievements. The path that appeared divergent from traditional legal success had actually provided superior preparation for the most prestigious appointment in American legal practice. Federal judicial service demanded comprehensive constitutional expertise that could only be developed through intensive practice in federal constitutional law. Corporate attorneys, regardless of their success in commercial litigation, typically lacked the constitutional knowledge required for effective judicial service in federal court. Criminal prosecutors, despite their trial experience, often possessed limited understanding of the constitutional questions that dominated federal judicial work. The irony was profound that my family's perception of career failure had blinded them to career preparation that exceeded anything available through traditional legal practice. While they focused on short-term indicators of professional success, I had been developing long-term qualifications for judicial service that represented the pinnacle of American legal achievement. The constitutional scholarship that seemed impractical to my family provided exactly the analytical framework that federal judicial service required. Federal judges regularly confronted novel constitutional questions that demanded innovative application of established constitutional principles to emerging factual situations. This work required the scholarly approach to constitutional interpretation that I had developed through academic writing and theoretical analysis. The federal appellate advocacy experience that my family considered narrow specialization provided precisely the sophisticated legal reasoning that federal judicial service demanded. Federal judges spent substantial portions of their time reviewing appellate briefs, evaluating legal arguments, and determining the constitutional principles that should govern federal court decisions. Effective performance in these responsibilities required the appellate advocacy skills that I had mastered through extensive federal court practice. The judicial staff experience that my family viewed as administrative work provided comprehensive understanding of federal court operations that proved essential for effective judicial service. Federal judges needed practical knowledge of case management procedures, administrative requirements, and the operational considerations that affected federal court efficiency. This practical knowledge complemented constitutional expertise to create comprehensive preparation for judicial responsibilities. The professional recognition within the federal judicial community that remained invisible to my family represented exactly the validation that judicial selection committees considered when evaluating potential nominees. Federal judges, constitutional scholars, and federal agency officials had recognized my expertise through consultation requests, collaboration opportunities, and educational program invitations. This professional recognition demonstrated the peer review that appointment committees valued in potential judicial nominees. The crystallizing moment revealed the strategic advantages that unconventional career development could provide for ambitious legal professionals. Traditional legal career paths often emphasized short-term advancement and immediate financial rewards, while neglecting the specialized expertise required for long-term professional achievements. Unconventional paths that focused on meaningful work and expertise development could provide superior preparation for significant opportunities. The constitutional law expertise that I had developed through federal practice exceeded the qualifications possessed by most attorneys who pursued traditional career advancement through corporate law firms or prosecutorial offices. The depth of constitutional knowledge required years of intensive practice in federal constitutional law, scholarly engagement with constitutional theory, and practical experience in constitutional interpretation and application. Federal judicial appointment represented recognition not merely of legal competence, but of exceptional constitutional expertise, and demonstrated commitment to judicial reasoning and constitutional interpretation. The appointment process evaluated potential nominees based on their mastery of constitutional law, their understanding of federal court operations, their scholarly contributions to legal development, and their professional recognition within the legal community. The crystallizing realization encompassed understanding that my professional development had positioned me not merely as a qualified candidate for federal judicial appointment, but as an exceptional candidate whose expertise exceeded typical appointment standards. The combination of constitutional scholarship, federal court experience, appellate advocacy skills, and judicial recognition created qualifications that appointment committees would find compelling. The moment also revealed the broader implications of my career choices for advancing opportunities for non-traditional legal professionals. Federal judicial appointment based on constitutional expertise rather than traditional career advancement would demonstrate that judicial excellence could emerge from diverse professional backgrounds and unconventional career paths. The constitutional law community would recognize my potential appointment as validation of the importance of specialized constitutional practice and scholarly engagement with constitutional theory. Federal judges and constitutional scholars understood the sophisticated expertise required for effective constitutional interpretation and would appreciate the depth of constitutional knowledge that my career had provided. Federal agencies that had consulted my expertise on constitutional questions would view potential judicial appointment as appropriate recognition of demonstrated constitutional competence. The consultation relationships I had developed with federal legal officials provided evidence of professional respect and confidence in my constitutional analysis. The crystallizing moment included recognition of the personal transformation that had occurred through 9 years of constitutional practice and federal court service. The insecurity and self-doubt that had characterized my early response to family dismissal had evolved into professional confidence and clear understanding of my constitutional expertise and judicial qualifications. The emotional growth paralleled professional development, creating integrated preparation for the personal and professional challenges that federal judicial service would present. Federal judges faced intense public scrutiny, political pressure, and the intellectual demands of constitutional interpretation. Effective judicial service required both professional competence and personal resilience that could withstand external pressure and maintain judicial independence. The family relationships that had been strained by career choices and mutual misunderstanding would face fundamental challenge when my judicial appointment became public. The revelation would require my family to reassess their understanding of legal careers, professional success, and their evaluation of my professional choices. The crystallizing moment encompassed anticipation of this family dynamic transformation and recognition that my appointment would provide opportunities for education and relationship healing. The family members who had dismissed my career choices would need to acknowledge their misunderstanding, while recognizing the validity of non-traditional professional development. The broader professional implications extended beyond individual appointment to encompass potential influence on federal judicial selection practices and recognition of diverse qualification pathways for judicial service. My appointment would demonstrate that constitutional expertise could be developed through various professional experiences, and that judicial excellence emerged from dedication to meaningful legal work rather than traditional career advancement. The constitutional law community would benefit from judicial service that reflected intensive practice in constitutional interpretation and scholarly engagement with constitutional theory. Federal court decisions would be enhanced by judicial reasoning that reflected deep understanding of constitutional development and practical experience in constitutional application. Federal criminal defendants would receive constitutional protection from judicial reasoning informed by extensive experience in constitutional defense and comprehensive understanding of constitutional protections. This perspective would enhance federal court decisions regarding constitutional criminal procedure and individual rights protection. The crystallizing moment concluded with absolute clarity regarding the path forward and complete confidence in my qualifications for federal judicial service. The expertise that nobody recognized had prepared me for constitutional interpretation at the highest level of American legal practice. The career that my family considered unsuccessful had provided preparation for the most prestigious appointment in federal legal service. The transformation from family disappointment to federal judicial nominee was no longer a distant aspiration, but an inevitable progression based on demonstrated expertise and professional recognition. The crystallizing moment had revealed not merely personal potential, but professional reality that would soon become public recognition. The foundation had been established through 9 years of constitutional practice, federal court service, and judicial preparation. The moment of clarity had arrived, and the path to federal judicial appointment stretched ahead with perfect visibility and complete certainty. The strategic planning phase began 3 days after my crystallizing moment of professional clarity, when Chief Judge Thompson requested a private meeting to discuss what she termed significant career opportunities that required careful consideration and confidential preparation. Her office, lined with leather-bound volumes of federal case law and adorned with photographs from 3 decades of federal judicial service, provided the setting for a conversation that would transform my understanding of judicial appointment processes and strategic professional positioning. Chief Judge Thompson began our discussion with characteristic directness regarding the realities of federal judicial selection and the strategic considerations that influence successful nominations. The federal judicial appointment process represented one of the most complex and politically sensitive aspects of American governmental operations, requiring careful coordination between judicial administrators, political officials, and legal organizations to identify candidates who possessed both exceptional qualifications and the practical ability to navigate confirmation procedures. The initial strategic consideration involved understanding the timeline and procedural requirements that govern federal judicial nominations. Federal judicial vacancies created specific windows of opportunity that required strategic positioning and comprehensive preparation to maximize the likelihood of successful nomination and confirmation. The retirement announcements of 3 federal district judges in the Northern District of Illinois had created anticipated opportunities that would require immediate strategic planning and systematic preparation. Federal judicial selection committees evaluated potential nominees based on comprehensive criteria that extended beyond legal expertise to include judicial temperament, professional reputation, scholarly contributions, and demonstrated commitment to constitutional principles. The evaluation process required extensive documentation of professional accomplishments, comprehensive background investigation, and detailed assessment of qualifications across multiple dimensions of judicial service. Chief Judge Thompson explained that my constitutional law expertise and federal court experience positioned me as an exceptionally qualified candidate for federal judicial appointment, but that successful nomination would require strategic presentation of qualifications and careful management of the political considerations that influence judicial selection. The appointment process demanded sophisticated understanding of both legal qualifications and political dynamics. The strategic planning process required comprehensive documentation of my professional accomplishments, scholarly contributions, and recognition within the legal community. Federal judicial selection committees conducted thorough evaluation of potential nominees, including review of published writings, analysis of legal advocacy, assessment of professional relationships, and investigation of personal and professional background. My constitutional law publications provided substantial evidence of scholarly engagement and intellectual contribution to legal development. The Northwestern University Law Review article addressing Fourth Amendment digital privacy questions demonstrated sophisticated constitutional analysis and innovative application of constitutional principles to emerging legal challenges. Additional scholarly contributions to federal practice journals and constitutional law symposiums provided comprehensive evidence of ongoing intellectual engagement with constitutional interpretation. Federal appellate advocacy victories established a documented record of legal excellence and professional competence that appointment committees considered essential for judicial qualification. The 17 federal appeals with favorable outcomes in 14 constitutional cases provided objective evidence of legal expertise and advocacy effectiveness. The Seventh Circuit decisions adopting my constitutional analyses demonstrated peer recognition of legal reasoning and scholarly contribution to federal law development. Professional recognition within the federal judicial community represented another crucial element of strategic positioning for judicial appointment. Federal judges' consultation requests, educational program invitations, and collaboration opportunities provided evidence of professional respect and confidence in constitutional expertise. The Federal Judicial Center presentations and judicial education contributions demonstrated recognition within the judicial community that appointment committees valued in potential nominees. The strategic presentation of qualifications required careful organization of professional accomplishments to highlight the specific expertise that federal judicial service demanded. Constitutional law mastery represented the foundation of federal judicial qualification, but appointment committees also evaluated practical experience, scholarly engagement, professional relationships, and demonstrated commitment to judicial independence and constitutional interpretation. Federal agency consultation work provided evidence of constitutional expertise that extended beyond academic analysis to include practical application in policy development and enforcement activities. The Department of Justice consultations regarding constitutional limitations on federal enforcement authority demonstrated recognition of expertise by federal legal officials and validation of constitutional analysis in practical governmental contexts. The strategic planning phase included comprehensive preparation for the intensive background investigation that federal judicial nomination required. The Federal Bureau of Investigation conducted exhaustive examination of potential nominees, including financial records, professional relationships, personal conduct, and any factors that might affect confirmation prospects. This investigation required complete transparency and comprehensive documentation of all personal and professional activities. Financial disclosure requirements for federal judicial nominees demanded detailed documentation of assets, investments, professional income, and potential conflicts of interest. Federal judges faced comprehensive ethical constraints that required divestment of investments that might create appearance of impropriety and ongoing disclosure of financial relationships that could affect judicial decision-making. Professional reference development represented another critical element of strategic preparation for judicial nomination. Federal judicial selection committees contacted professional colleagues, judicial officials, scholarly collaborators, and legal organization leaders to assess potential nominees' qualifications, character, and suitability for judicial service. The strategic cultivation of professional relationships that could provide meaningful references required careful consideration of individuals who possessed both knowledge of my qualifications and credibility within the legal community. Federal judges who had observed my constitutional advocacy and judicial staff work provided the most valuable professional references because they possessed direct knowledge of constitutional expertise and practical understanding of judicial service requirements. Chief Judge Thompson indicated her willingness to provide comprehensive endorsement based on 9 years of observation of my constitutional analysis and judicial reasoning capabilities. Constitutional law scholars who had collaborated on research projects and conference presentations provided academic validation of scholarly engagement and intellectual contribution to constitutional development. The scholarly community's recognition enhanced credibility with appointment committees that valued intellectual rigor and ongoing engagement with legal scholarship. Federal agency officials who had consulted my constitutional expertise provided evidence of practical application and professional recognition beyond academic and judicial circles. The validation of constitutional analysis by federal legal officials demonstrated real-world impact and professional competence that appointment committees considered important for judicial qualification. Legal organization endorsements represented additional strategic considerations for successful judicial nomination. Professional associations, bar organizations, and specialty legal groups often provided formal evaluations of judicial nominees that influenced appointment committee decisions and public perception of nomination appropriateness. The American Bar Association's Standing Committee on the Federal Judiciary conducted comprehensive evaluation of federal judicial nominees, including assessment of professional competence, judicial temperament, and ethical standards. The ABA evaluation process required extensive documentation of qualifications and comprehensive interview procedures that examined all aspects of professional preparation for judicial service. Specialized constitutional law organizations provided additional opportunities for professional endorsement and validation of constitutional expertise. The American Constitution Society and similar organizations evaluated judicial nominees based on demonstrated commitment to constitutional principles and scholarly engagement with constitutional interpretation. The strategic timing considerations for judicial nomination required careful coordination with political calendars and administrative priorities. Federal judicial nominations faced varying prospects for confirmation depending on political dynamics, Senate schedules, and competing governmental priorities that influenced legislative attention to judicial appointments. Presidential election cycles created specific windows of opportunity and challenge for judicial nominations. Political considerations affected both nomination decisions and confirmation prospects, requiring strategic assessment of optimal timing for nomination submission and confirmation proceedings. Senate calendar management influenced confirmation timing and required strategic coordination with judicial selection officials to optimize confirmation prospects. The legislative schedule, competing policy priorities, and political dynamics all affected the practical timeline for judicial confirmation and required strategic planning to maximize success probability. The confidentiality requirements that govern judicial nomination procedures created unique challenges for personal and professional relationship management. Federal judicial nomination discussions required absolute discretion to protect the integrity of selection processes and prevent premature public speculation that could complicate confirmation proceedings. Family relationship management represented a particularly complex aspect of maintaining nomination confidentiality while preparing for the eventual public revelation of judicial appointment. My family's continued dismissive attitude toward my career required careful navigation to maintain normal relationships while concealing the most significant professional development of my legal career. Professional relationship management during the confidential nomination phase required continued normal interactions with colleagues and legal contacts while avoiding any indication of pending appointment that could compromise selection procedures. The maintenance of professional routine during nomination preparation demanded sophisticated personal management and absolute discretion. The strategic communication planning for eventual public announcement of judicial nomination required comprehensive preparation for media attention, professional recognition, and family relationship transformation. Federal judicial appointments generated significant public interest and professional attention that required careful management to maintain appropriate judicial dignity and professional decorum. Media relations preparation included development of appropriate responses to anticipated questions about judicial philosophy, constitutional interpretation, and professional background. Federal judicial nominees faced intensive scrutiny regarding their qualifications, background, and judicial approach that required careful preparation and strategic communication. Professional community outreach required planning for appropriate acknowledgement of support and recognition while maintaining judicial independence and avoiding appearance of political favoritism or inappropriate influence. Federal judges faced stringent ethical requirements that began during nomination proceedings and required careful navigation of professional relationships. Family relationship transformation planning represented the most personally significant aspect of strategic preparation for judicial nomination. The revelation of federal judicial appointment would fundamentally challenge my family's understanding of legal careers and require comprehensive reassessment of their evaluation of my professional choices and achievements. The strategic approach to family revelation required careful consideration of timing, communication methods, and relationship management during the transition from dismissal to recognition. The transformation would provide opportunities for education and relationship healing, while potentially creating temporary tension as family members processed their misunderstanding of my career development. The strategic planning phase concluded with comprehensive preparation for judicial nomination submission and complete confidence in my qualifications for federal judicial service. The constitutional expertise that had developed through 9 years of federal practice provided exceptional preparation for judicial appointment that exceeded typical nominee qualifications. The professional recognition within the judicial community validated my readiness for federal judicial service and supported strategic positioning for successful nomination and confirmation. The foundation had been established through systematic strategic planning that addressed every aspect of federal judicial nomination and confirmation. The transformation from overlooked family member to federal judicial nominee required only the completion of selection procedures and the public announcement that would reveal the true significance of my unconventional career path and challenge every assumption about professional success and judicial qualification. The first demonstration of my constitutional expertise in a context that would generate broader professional recognition occurred during the landmark case of United States versus Digital Privacy Coalition, a federal class action that challenged the constitutional validity of comprehensive federal digital surveillance programs. The case required sophisticated analysis of Fourth Amendment privacy protections in the digital age and represented the type of complex constitutional litigation that would establish precedent for decades of future federal court decisions regarding governmental surveillance authority and individual privacy rights. Chief Judge Thompson assigned me to lead the constitutional research team that would provide analytical support for the federal court's evaluation of the constitutional questions presented in this groundbreaking case. The assignment represented recognition of my constitutional expertise while providing an opportunity to demonstrate the sophisticated legal analysis that would be required for federal judicial service. The case would test every aspect of my constitutional knowledge and provide visible evidence of my qualifications for judicial appointment. The constitutional questions presented in Digital Privacy Coalition required comprehensive analysis of Supreme Court precedent regarding privacy expectations, technological developments that challenged traditional constitutional frameworks, and the complex balance between national security interests and individual constitutional protections. The legal issues demanded understanding of constitutional history, technological policy, federal law enforcement operations, and the practical implications of different constitutional interpretations for American society. The federal government's surveillance programs encompassed electronic communications monitoring, financial transaction analysis, travel pattern tracking, and comprehensive data collection activities that raised fundamental questions about the scope of Fourth Amendment protections in contemporary technological environments. The constitutional analysis required understanding both the historical development of privacy doctrine and the innovative application of constitutional principles to emerging surveillance technologies. The initial constitutional research phase required comprehensive examination of Supreme Court decisions addressing privacy expectations and governmental surveillance authority. The foundational privacy cases established constitutional principles that required careful application to digital surveillance technologies that did not exist when the original constitutional framework was developed. The legal analysis demanded innovative constitutional reasoning that respected established precedent while addressing unprecedented technological circumstances. Katz v. United States established the fundamental principle that Fourth Amendment protections extended to reasonable expectations of privacy rather than merely physical intrusion into protected spaces. The decision required analysis of whether individuals possessed reasonable privacy expectations in digital communications and electronic transactions that occurred through technological systems operated by private companies but accessible to federal surveillance programs. Smith v. Maryland addressed the constitutional status of information voluntarily conveyed to third parties and established the third-party doctrine that limited Fourth Amendment protections for information shared with commercial entities. The digital surveillance context required sophisticated analysis of whether the third-party doctrine applied to comprehensive data collection that exceeded the limited information sharing contemplated in traditional constitutional analysis. United States v. Jones addressed GPS tracking and established that prolonged surveillance could constitute a search requiring constitutional protection even when individual instances of data collection might not trigger Fourth Amendment analysis. The principle required application to comprehensive digital surveillance programs that collected vast quantities of individual data over extended time periods. Riley v. California addressed digital device searches and recognized that digital devices contained unprecedented quantities of personal information requiring enhanced constitutional protection. The decision provided foundation for analysis of digital surveillance programs that accessed similar comprehensive personal information through technological rather than physical means. The constitutional research team that I assembled included federal public defenders with specialized expertise in digital privacy law, academic constitutional scholars with extensive surveillance research experience, and technology policy experts who understood the technical operations of federal surveillance programs. The multidisciplinary approach ensured comprehensive analysis that addressed both constitutional law and technological policy considerations. The research methodology required systematic examination of federal court decisions addressing digital surveillance, comprehensive analysis of international constitutional approaches to privacy protection, and extensive evaluation of empirical research regarding the effectiveness and constitutional implications of federal surveillance programs. The analytical framework needed to address both legal precedent and practical policy considerations that influenced constitutional interpretation. Federal appellate court decisions from multiple jurisdictions provided varying approaches to digital surveillance questions that required careful analysis and synthesis. The Second Circuit, Ninth Circuit, and D.C. Circuit had addressed different aspects of digital surveillance with varying constitutional conclusions that required comprehensive evaluation to identify emerging trends in constitutional interpretation and potential Supreme Court resolution of conflicting appellate approaches. International constitutional law provided comparative perspective on privacy protection and surveillance regulation that enhanced understanding of alternative constitutional approaches and their practical implications. European Union privacy protections, Canadian constitutional law, and other democratic constitutional systems provided models for balancing national security interests with individual privacy rights. The technical analysis of federal surveillance programs required collaboration with computer science experts, telecommunications specialists, and cybersecurity professionals who understood the operational details of digital surveillance technologies. The constitutional analysis needed to address the actual capabilities and limitations of surveillance systems rather than theoretical or speculative surveillance scenarios. The constitutional brief that resulted from 6 months of intensive research comprised 473 pages of legal analysis supported by comprehensive examination of constitutional precedent, technological developments, and policy considerations. The brief addressed every aspect of Fourth Amendment digital privacy protection and provided innovative constitutional framework for evaluating federal surveillance programs. The constitutional analysis established that comprehensive digital surveillance programs created constitutional concerns that exceeded traditional third-party doctrine limitations and required enhanced Fourth Amendment protection. The legal reasoning demonstrated that technological capabilities for comprehensive individual monitoring created constitutional implications that demanded careful judicial evaluation and appropriate constitutional safeguards. The brief argued that prolonged digital surveillance constituted searches requiring constitutional justification, even when individual data collection activities might not trigger Fourth Amendment protection under traditional analysis. The constitutional framework recognized that technological aggregation of individual information created comprehensive personal profiles that required constitutional protection regardless of the constitutional status of individual data elements. The constitutional analysis addressed national security considerations while maintaining appropriate constitutional protections for individual privacy rights. The legal framework recognized legitimate governmental interests in national security, while requiring constitutional procedures that ensured appropriate oversight and prevented unreasonable surveillance activities. The oral argument phase provided the first public demonstration of my constitutional expertise before federal appellate judges with extensive constitutional law background. The argument required sophisticated understanding of constitutional doctrine, quick analytical responses to complex judicial questions, and effective advocacy that balanced legal precision with accessible explanation of complex constitutional principles. Chief Judge Thompson authorized my presentation of the constitutional analysis during the federal court hearing, recognizing that my research had produced the most comprehensive constitutional examination of digital surveillance questions available to the federal court. The opportunity represented validation of my constitutional expertise while providing visible demonstration of my qualifications for judicial appointment. The federal appellate panel included judges with extensive constitutional law experience, who posed challenging questions about constitutional interpretation, policy implications, and the practical application of constitutional principles to complex technological environments. The judicial questioning tested every aspect of my constitutional knowledge and required sophisticated responses that demonstrated mastery of constitutional doctrine and innovative legal reasoning. Judge Patricia Williams questioned the historical foundation for applying Fourth Amendment protections to digital surveillance technologies that did not exist when constitutional privacy protections were originally developed. The response required comprehensive understanding of constitutional interpretation methodology and the principles governing constitutional application to technological developments. Judge Michael Chen addressed the policy implications of enhanced constitutional protection for digital privacy and questioned whether constitutional constraints would prevent effective federal law enforcement and national security operations. The analysis required careful balance between constitutional requirements and practical governmental needs. Judge Sarah Rodriguez examined the relationship between digital surveillance constitutional analysis and existing Supreme Court precedent regarding privacy expectations and third-party information sharing. The questions demanded precise understanding of constitutional doctrine and innovative application to unprecedented technological circumstances. The judicial response to my constitutional analysis exceeded expectations and validated the sophistication of my legal reasoning and constitutional expertise. Judge Williams specifically commended the comprehensive nature of the constitutional research and the innovative application of established constitutional principles to emerging technological challenges. Judge Chen noted that the constitutional analysis provided the most thorough examination of digital surveillance questions that the federal court had encountered, and praised the careful balance between constitutional protection and practical governmental considerations. The judicial recognition validated my constitutional expertise while establishing my reputation within the federal judicial community. Judge Rodriguez highlighted the scholarly quality of the constitutional research and the effective integration of legal precedent with technological understanding and policy analysis. The comprehensive approach demonstrated the multidisciplinary expertise required for effective constitutional analysis in complex technological contexts. The federal court decision adopting substantial portions of my constitutional analysis established important precedent regarding digital surveillance constitutional requirements, and was immediately recognized as a landmark decision in Fourth Amendment digital privacy law. The opinion specifically credited the quality of the constitutional research and the innovative legal reasoning that addressed unprecedented constitutional questions. Federal appellate courts in other jurisdictions began citing the constitutional analysis from Digital Privacy Coalition as authoritative examination of Fourth Amendment digital privacy questions. The precedential impact demonstrated the national significance of the constitutional reasoning and established my reputation as a leading expert in constitutional privacy law. Constitutional law scholars recognize the Digital Privacy Coalition analysis as groundbreaking constitutional scholarship that advanced understanding of Fourth Amendment protection in digital environments. Law review articles examining the decision praised the sophisticated constitutional reasoning and the innovative application of constitutional principles to technological challenges. Federal agencies requested copies of the constitutional analysis for their legal training programs and policy development activities. The Department of Justice incorporated elements of the constitutional framework into their digital surveillance guidelines, recognizing the practical value of the constitutional analysis for federal law enforcement operations. The professional recognition generated by the Digital Privacy Coalition demonstration extended throughout the federal legal community and established my reputation as a constitutional expert with specialized knowledge of emerging constitutional questions. Federal judges began requesting consultation on similar constitutional issues, and constitutional scholars invited collaboration on related research projects. The Federal Judicial Center invited me to present analysis of the Digital Privacy Coalition decision at their national conference for federal judges. The presentation provided opportunity to explain the constitutional reasoning to judicial audiences across the country and established my recognition as a leading authority on digital privacy constitutional law. Legal education institutions requested guest lectures addressing the constitutional implications of digital surveillance and the innovative legal reasoning demonstrated in the Digital Privacy Coalition analysis. The academic recognition validated the scholarly quality of my constitutional work while establishing my credentials within the legal education community. Federal bar associations invited presentations addressing the practical implications of enhanced digital privacy constitutional protection for federal criminal practice. The professional programs provided opportunities to educate practicing attorneys about constitutional developments, while demonstrating my expertise to broader legal audiences. The first demonstration of constitutional expertise through the Digital Privacy Coalition case established comprehensive recognition of my qualifications for federal judicial service, while providing visible evidence of the sophisticated legal analysis required for effective constitutional interpretation. The professional recognition validated years of constitutional development and positioned me as a leading candidate for federal judicial appointment. The success of the Digital Privacy Coalition demonstration proved that unconventional career development could produce constitutional expertise that exceeded traditional judicial qualification standards. The innovative constitutional analysis demonstrated intellectual capabilities and professional competence that appointment committees would find compelling for federal judicial service. The demonstration established foundation for additional opportunities to display constitutional expertise and build recognition within the federal legal community. The visible success created momentum for continued professional development and enhanced prospects for federal judicial appointment that would vindicate years of dedicated constitutional practice. The escalating challenge arrived 6 weeks after the Digital Privacy Coalition victory, when the Attorney General of the United States personally requested my constitutional analysis for the most significant federal criminal law case to reach the Supreme Court in a decade. United States v. Constitutional Defense Alliance presented fundamental questions about the balance between federal enforcement authority and individual constitutional rights that would determine the scope of federal criminal jurisdiction for generations. The request represented extraordinary recognition of my constitutional expertise, while creating unprecedented responsibility for legal analysis that would influence Supreme Court decision-making and American constitutional development. The Constitutional Questions and Constitutional Defense Alliance arose from a complex federal prosecution involving allegations of domestic terrorism that challenged the fundamental boundaries between federal criminal authority and constitutional protection of individual rights. The case required comprehensive analysis of Commerce Clause power, due process limitations on federal jurisdiction, First Amendment protection of political advocacy, and the constitutional principles governing federal criminal law enforcement in cases involving political dissent and civil disobedience. Attorney General David Patterson explained during our initial consultation that the constitutional implications of the case exceeded normal federal prosecution considerations and required the most sophisticated constitutional analysis available within the federal legal system. The Supreme Court had granted certiorari based on conflicting federal appellate decisions regarding constitutional limitations on federal criminal jurisdiction, creating the need for comprehensive constitutional briefing that would address fundamental questions about federal governmental power and individual constitutional protection. The Supreme Court briefing responsibility represented recognition that my constitutional expertise exceeded that available through traditional federal legal channels and demonstrated confidence in my analytical capabilities that validated years of constitutional development. The opportunity required comprehensive mastery of constitutional doctrine, sophisticated understanding of Supreme Court decision-making processes, and innovative legal reasoning that could influence constitutional interpretation at the highest level of American legal practice. The constitutional research phase for Supreme Court briefing demanded comprehensive examination of constitutional text, historical interpretation, Supreme Court precedent, and the theoretical frameworks that guided contemporary constitutional analysis. The legal questions required understanding constitutional principles that had developed over more than 2 centuries of American constitutional experience, while addressing contemporary circumstances that challenged traditional constitutional applications. Commerce Clause analysis formed the foundation of federal criminal jurisdiction and required comprehensive understanding of the constitutional principles governing federal regulatory authority. The Supreme Court had interpreted Commerce Clause power through numerous historical periods, with varying approaches to federal authority that required careful synthesis to identify contemporary constitutional standards and their application to federal criminal law. The constitutional history of Commerce Clause interpretation encompassed fundamental questions about federalism, individual rights, and the proper scope of national governmental authority that had shaped American constitutional development since the founding era. Understanding this constitutional evolution required mastery of Supreme Court decisions spanning more than 2 centuries of constitutional interpretation and the policy considerations that had influenced judicial reasoning regarding federal power. Wickard v. Filburn established broad federal authority to regulate economic activities that affected interstate commerce, even when individual activities appeared purely local in nature. The decision required analysis of whether federal criminal prosecutions could be based on Commerce Clause authority when alleged criminal activities involved political advocacy rather than commercial transactions. United States v. Lopez limited federal Commerce Clause authority and established that federal criminal jurisdiction required substantial connection to interstate commerce rather than mere federal legislative assertion of constitutional power. The decision created an analytical framework for evaluating federal criminal prosecutions that required careful application to cases involving political activities and individual constitutional rights. United States v. Morrison further restricted federal Commerce Clause authority and established that federal criminal jurisdiction could not be based on purely local criminal activities regardless of their potential economic effects. The constitutional analysis required understanding how these limitations applied to federal prosecutions involving political advocacy that might affect interstate economic activity. Due process constitutional analysis required comprehensive understanding of both substantive and procedural constitutional protections that limited federal criminal law enforcement authority. The 5th and 14th Amendments established fundamental fairness requirements that governed federal prosecution procedures and substantive limitations on federal criminal jurisdiction that protected individual constitutional rights. Substantive due process analysis addressed whether federal criminal prosecutions exceeded constitutional limitations on governmental authority and violated fundamental constitutional principles regarding individual liberty and governmental power. The constitutional analysis required understanding Supreme Court decisions regarding substantive constitutional rights and their application to federal criminal law enforcement. Procedural due process requirements governed federal prosecution procedures and established constitutional standards for fair treatment of individuals facing federal criminal charges. The constitutional analysis required comprehensive understanding of federal criminal procedure and the constitutional protections that ensured fundamental fairness in federal prosecution. First Amendment constitutional analysis presented the most complex constitutional questions in the Constitutional Defense Alliance case. Because the federal prosecution involved political advocacy and civil disobedience activities that received substantial constitutional protection under Supreme Court precedent. The constitutional analysis required careful balance between federal criminal law enforcement authority and constitutional protection of political speech and association. Brandenburg v. Ohio established the constitutional standard for government restriction of political advocacy and required that federal prosecution of political speech demonstrate imminent lawless action rather than mere advocacy of illegal activities. The constitutional framework required sophisticated application to federal criminal prosecutions that involved political advocacy and civil disobedience. The constitutional analysis required distinguishing between protected political advocacy and criminal conduct that exceeded constitutional protection while ensuring that federal criminal prosecutions did not violate First Amendment rights through selective enforcement or excessive punishment of political dissent. Up next, you've got 2 more standout stories right on your screen. If this one hit the mark, you won't want to pass these up. Just click and check them out. And don't forget to subscribe and turn on the notification bell so you don't miss any upload from us.